administrative action, we know, is defined by PAJA, and there are two aspects to the definition. The first relates to decisions by organs of state, and this is a definition in section 1B of PAJA. The first relates to decisions of organs of state when they are exercising public functions in terms of a constitution or a provincial constitution or in terms of any legislation. That can safely be excluded because we are not dealing here with a decision by an organ of state. What therefore remains is whether this qualifies as an administrative action under section 1B of PAJA, which applies to a decision of a natural or juristic person other than an organ of state. But it only applies when that natural or juristic person is exercising a public power or performing a public function in terms of an empowering provision. Presumably, this must be the only basis why the respondents insist that we should have relied on PAJA. But we say there is a fundamental problem with the argument, because the fact that the decision is not taken by an organ of state still does not detract from the fact that it must be taken in terms of an empowering provision. And an empowering provision must be an empowering legislation, an empowering statute. Those are the statutes that grant the authority to a person other than an organ of state. So we say that at the fundamental level, this is not a decision taken in accordance with an empowering provision. This is a decision taken in accordance with the constitution of the ANC, which is a voluntary association. And that constitution of the ANC has got no statutory origins. What the applicants say is that all political parties derive their authority from the constitution in its broadest possible sense. But that argument simply makes no sense, because virtually everything in this country, a company itself can find some kind of constitutional recognition. But when PAJA refers to an empowering provision, it should be given a narrow construction. It is intended to prescribe a reference to a statute or an act of parliament or a provincial act. But the empowering provision must always be an act that has been passed either by parliament or a provincial parliament.
Is there authority for that?
Well, we would submit with respect that if one looks at the judgments that we have cited in particularly the SCA judgment of Caliber Clinical Consultants versus National Bargaining Council for the Road Freight Industry, and in paragraph 10 of our heads of argument, this is Justice Nugent of the SCA. Admittedly, my lord, this is not a judgment dealing with the actions of political parties, but it is a judgment dealing with a voluntary association, a bargaining council. Yeah. And it's common ground that political parties are voluntary associations. And if one looks at paragraphs 41 and 42, particularly paragraphs 42, where Justice Nugent explains why decisions of a bargaining council in relation to its members, not in relation to the public at large, but in relation to its members, those are not covered by the provisions of PAJA. And let's look at paragraph 14, PAJA. And let's look at paragraph 41 first, where he says, a bargaining council, like a trade union and an employers association, is a voluntary association that is by agreement to perform functions in the interest and for the benefit of its members. I have considerable difficulty seeing how a bargaining council can be said to be publicly accountable for the procurement of services for a project that is implemented for the benefit of its members, whether it be a medical aid scheme or a training scheme or a pension fund, or, as in this case, its wellness program. So what's clear here is that he looks at the relationship on a horizontal level, that is the bargaining council acting in its relationship with its members. Then he explains what he means in paragraph 42. I do not find in the implementation of such a project any of the features that have been identified in the cases as signifying that it is subject to judicial review. When implementing such a project, a bargaining council is not performing a function that is woven into a system of governmental control or integrated into a system of statutory regulation. And this is the point I make about the statutory source of the power. Government does not regulate, supervise, or inspect the performance of the function. The task is not one for which the public has assumed responsibility. It is not linked to the functions and powers of government. It is not privatization of the business of government. There is not potentially a government interest in the decision-making power in question. The council is not taking the place of central government or local authorities. And most importantly, it involves no public money. it is true that a government might itself undertake a similar project on behalf of the public at large, just as it might provide medical services generally and pensions and training schemes to the public at large. But the council is not substituting the government when it provides such services to employees with whom it is in a special relationship. So this is the most important aspect, is that the ANC acts in relation to its members when it convenes a provincial conference. And your Lordship will see a case that is referred to by our learned friends, which is the Van Zyl versus New National Party government. And one, you will be struck by how distinct that case is from the facts of this particular case. Because, of course, what happened in the Van Zyl versus New National Party, it was a recall of by secret ballot, incidentally. It was a recall of a representative of the National Party in the provincial legislature. And the clauses that were directly engaged were the constitutional clauses. I think it was Section 106 or Section 102 of the Constitution. And it was in that particular context that the Western Cape High Court finds that if a political party is to insist that one of its public representatives in Parliament ought to be recalled, that recall is governed by public law principles. Because, of course, to execute that recall, it is essential that the majority party should sit and vote in its capacity as a member in Parliament. And so that was the key distinction in the Van Zyl decision. And we see in the bundle of authorities handed up by our learned friends that they ultimately pinned their colors to the New National Party decision. But we would submit with respect that New National Party did not set a general principle applicable to all decisions of political parties. It depends on the capacity that the political party is acting. What I've demonstrated here by reference to the Caliber Clinical Consultants decision is that where a voluntary association acts in its private capacity in relation to its members, that decision is outside the strictures of public law. Now, so those are the points that are made in paragraph 7.1, 7.2, and 7.3. That takes me then to paragraph 7.4 of my written argument, because there we then engage directly with what the applicants argue, where they say that the actions of the ANC constitutes actions which form part of the political process, which is inherently a public function. But we submit here that this is a misunderstanding. It is true that the ANC is a political party, and it is true that the public has an interest in what the ANC does qua political party. But one must still look at the nature of the power being exercised. This is a power deriving directly from the constitution of the ANC. It is not a power in the general public sense that is regulated by statute. So we would submit that to argue that because you are a political party and because the public has an interest in what you do, still does not take the decision to the parameters of administrative action, because it still lacks the statutory and the public element. And of course, there is a fundamental problem. They have not demonstrated an empowering provision, and that empowering provision ought to be a statute if one considers properly the decision of Caliber Clinical Consultants. Those are the first two arguments why this is outside the definition of an administrative action under PAJA. And there's a third argument, and this is what we deal with in paragraph 8 of our heads of argument, that the ultimate point of PAJA is to concern itself with what is referred to as the conduct of the administration, the conduct of government, the conduct of organs of state, or sometimes the conduct of private parties, where in effect, as Justice Nugent points out, they have substituted the organs of state. So, for instance, a case such as Cash Paymaster, there the Constitutional Court had no difficulty in finding that although Cash Paymaster is a private company, it nevertheless is bound by public law, because when it distributes social grants, it does so in its contractual capacity in order to serve the public as a whole. That's completely different from a political party concerned with how internally it must elect its own members, its own leadership. So we would say that if one looks at the ultimate point that is served by PAJA, and this is the point that Justice Wallace makes in the Sokela decision at paragraph 60 by reference to the Grays Marine judgment, that from the definition of the word decision in PAJA, the decision must be one of an administrative nature. And he continues to make it clear that the ultimate point of PAJA is to be concerned with the conduct of the administration. So that immediately then excludes the provisions of PAJA from being of application in this particular case. And I've already also referred to the Van Zyl decision, and I've tried to illustrate to the court why that decision finds no application in the particular set of case. It's perfectly understandable why the court came to that decision, because it was about a removal of a public representative in Parliament, and that removal could only take place in accordance with the provisions of the Constitution. But had it been the mere election of a representative of that party, that would not implicate the provisions of PAJA at all. Those three arguments should be sufficient to dispose of the question whether or not this is a decision that falls within the purview of administrative action under PAJA or not. But then there is a further argument. We make this argument by reference to Makhanya versus University of Zululand, and this is again a judgment by Justice Nugent. And we've cited the relevant passage, which is paragraph 45, at paragraph 12 of our heads of argument. And so the proposition is the following. If you have two alternative causes of action, you have a cause of action in dealings, in labor law, and in contract, and you go to court based on a contractual cause of action. And your lordships will recall, and my lady, will recall the traditional point which was resolved by Makhanya. Employees would go to court on a contractual basis, and then the High Court would say, sorry, you have a claim under labor law, under the Labor Relations Act, and therefore you should pursue that claim. That was dismissed entirely in Makhanya, when Justice Nugent found in paragraph 45, where he says, I think it is patent that the High Court would not have declined to consider the claim, a claim that asserted a right in delict, only because the company had an alternative claim arising from the same facts, enforceable in another court. The claim that was before it was a claim in delict, and it fell within the power and the duty of the High Court to consider that claim, if only to dismiss it. That there was another claim enforced in another court was irrelevant. And so this is what we are dealing with here. We are being told that you have another cause of action, pursue that cause of action. But Justice Nugent reminds us that that is completely irrelevant. What is before the court is the claim chosen by the applicant. It's a claim not founded on PAJA, and because it's a claim not founded on PAJA, the court must consider whether the claim before it is a good or a bad claim. It doesn't help to say that you've got another claim. Our learned friends refer to a recent judgment by the Supreme Court of Appeal. I forget the citation, but it's a judgment which basically deals with the question of legality and PAJA, and says that if you have a PAJA, if the decision falls within the definition of PAJA, then you cannot, in a sense, take the legality argument and put it in your back pocket so that whenever it's convenient,
You're referring to Gijima.
It's Gijima, yes, correct, my lord, thank you. They refer to the Sita versus Gijima. They refer to the Sita versus Gijima judgment. But that is inapplicable to the present facts of this case, because, of course, Gijima was dealing with a unique set of situations. What it was dealing with is basically the kind of abuse, because PAJA allows you the right to sue under legality, because one of the PAJA grounds is that a decision that is outside the parameters of an empowering provision can be set aside. And therefore, what the SCA was dealing with is that it's inappropriate for parties who have a claim under PAJA to then leave their so-called legality claim until the last moment and say, well, I'm out of time and therefore I'm relying on legality. We are not relying in this case, as it happened in that case, on PAJA, alternatively on legality. Because what the court found in that case is that once we've dealt with your case on PAJA, you cannot say, oh, well, I have an alternative claim under PAJA. PAJA applies, and because PAJA applies, that is the end of the matter. But it is only where PAJA applies. It is not a case where PAJA does not apply that Gijima becomes important. So the critical distinction that we submit with respect is overlooked by our learned friends, is that it is only when PAJA applies that a court will then refuse to entertain an alternative claim based on legality, because it will say, of course, you must follow PAJA because PAJA is of application. It does not apply where PAJA is not of application, such as the current instance. In any event, and I point out in the Makhanya case that once you've pursued a claim purely based on the contract of the political party, the court must consider that claim before it. Now, the last point to be made here is Ramakatsa. And Your Lordships will remember there were split judgments in Ramakatsa. There were 2 minorities and 1 majority judgment. One of the points taken by the minority judgments was that the applicants' grounds of review were weak in relation to some aspects of the conference. And they said because your public law grounds of review, and this is the minority judgments, because your public law grounds of review were weak, the entire claim was dismissed by the minority. That was judgment by Justice Yakub and the judgment by Justice Froneman. But the majority judgment, which was delivered by Justice Musenega, took a completely different view. We see this in paragraph 130 of the judgment. And he criticizes the approach of the minority by turning a blind eye on the true cause of action raised by the applicants. And we've cited the relevant passage in paragraph 14 of our heads of argument, where Justice Musenega emphasizes the importance of a correct characterization of the claim brought by the applicants. And this is what he says. In our view, this characterization of the appellants, this is the characterization about the review of the decisions of the appellant's case, is inaccurate. It is incomplete. The review claim was one of 3 causes of action. The other causes of action were those which we find were established, namely, their right to participate in the activities of the ANC was violated when they were prevented from taking part in meetings of the ANC. This is a constitutional claim based on the right entrenched in Section 19 of the Constitution. The second cause of action is contractual. It is based on the breach of the ANC's Constitution and its audit guidelines. The irregularities referred to above establish both these causes of action. Now, this is precisely where we are with this case. What the applicants have come to court for is they have come to say the manner in which the provincial conference was convened breached our Section 19 rights under the Constitution. They have also come to say the manner in which this conference was held breached our contractual rights as members of the ANC. We now know that PAJA is not a stumbling block. We also know that Ramakatsa, in fact, imposes an obligation on the court to consider the claim that has been pursued by the applicant, and that there are other claims that may or may not exist is entirely irrelevant. So, we would therefore submit that the PAJA defense has got no application. The 180-day rule does not apply. But on the facts, we'll say that your Lordships and my lady would not have to bother yourselves with the question whether or not this does or does not apply, because you have to look at the alleged delay in its proper perspective. What we know about these decisions that are in issue here is that it is true the provincial conference was finalized in November 2015, and it is true that the proceedings were instituted in July 2017, sorry, 2016, and July 2016, 22 July 2016. But one must look at the entire chain of events. The first important instance that we've referred to in our heads of argument is what appears at page 106, particularly paragraphs 165 to 167 of the applicant's founding affidavit. What the applicants say is that once the provincial conference was finalized, there were several irregularities and several complaints that were lodged. They obviously took the responsible thing, which is to refer the matter to the National Executive Committee. It is common cause that the National Executive Committee, under the Constitution of the ANC, is the highest decision-making body in the affairs of the ANC. And then they say the responsible thing to do was first to lodge the complaint that we had with the highest decision-making body. And what is curious about this delay point that is now taken against the applicants is that when President Zuma and 4 other members of the NEC were here on the 12th of December 2015 at a meeting at Coatlands, what they said to the applicants was that they would respond to their concerns within 5 days of that meeting. He never did so. He never responded to the applicants within 5 days. And my lord, you will remember, when President Zuma makes this undertaking to the applicants, they must take him seriously. They cannot assume that President Zuma is not going to fulfill his undertaking. They should not assume that members of the NEC, particularly the top 6, are not going to fulfill their obligation. So we would submit that the responsible thing to do was first to explore whether or not the dispute, that the complaints that they had, could not be resolved within the structures of the ANC itself, particularly within the NEC. Now, how long did they wait thereafter? He says to them, 12th of December, I'm coming back to you in 5 days. He never does. For 5 months, does nothing about their response, until the applicants write a letter through their attorney to the Secretary General, Mr. KwaZulu-Natal. What does Mr. KwaZulu-Natal do? He himself does not address the problems. He simply complains that he should not be engaged through attorney's letters. At that point, what then happens is that in May 2016, the letter was in April. Yes, I am told that the letter is in April of 2016, and that's the letter to the Secretary General of the party. But in May 2016, they then induct the new PEC. They come here, they endorse them, they induct them. They say, now you are official, you are the new PEC, and it's been recognized. Prior to that induction, given the undertakings that were made by President Zuma, and given the fact that the applicants were doing the responsible thing by waiting for the NEC to resolve their complaints, one cannot seriously accuse the applicants of having delayed the bringing of these proceedings to court. In fact, the applicants were doing the responsible thing. And you know, my lord, one has many of these complaints about undue delay being raised. If the applicants had come to court in January 2017, no doubt the very complaints would have been, you have come to court prematurely because the matter is still being considered by the NEC. Yes, January 2016. They would have been accused of having come to court prematurely because the ANC NEC is still seized with the matter. They now come to court, they are told, no, you've delayed. What we don't understand is why President Zuma did not fulfill his undertaking. And what we don't understand is why Mr. KwaZulu-Natal tells them that they shouldn't engage him through attorneys. So we would submit with respect that this is a convenient answer to the applicant's claim. And it's a convenient answer that is entirely inconsistent with the way in which the constitution of the ANC is framed, that entitles applicants such as my clients to ask the NEC to intervene and to resolve their concerns. Because to come to court without having given the NEC to resolve its concern itself is problematic. So we would say that if one looks on a proper sequence of the events, one has regard to the fact that the provincial conference is finalized in November. In December, President Zuma undertakes to come back within 5 days. He, in fact, fails to do so. In April, there's a letter to Mr. KwaZulu-Natal, and then in May, we now know that there is an induction. It is only at that point that it becomes apparent to my clients that, well, they must now proceed with their litigation. What is said in the fourth affidavit filed on the 2nd of August by the respondents is that you were aware of the finality of the decision in relation to the provincial conference by the end of November 2015. But that is not the point here. It is true that the applicants were aware that the conference was final, but the issue was that they were not aware that their complaints flowing from the conference had been finally resolved. This case is not about the finality of the conference. Everybody accepts that the conference was finally held. This case is about the irregularities that happened after the conference. So the issue of the delay only applies insofar as the irregularities are concerned. It has no bearing on whether the conference was final or not. So for them to say there was a press conference, a press release issued by the NEC, which announced to the world that they were congratulating the provincial elected conference and they were congratulating the new NEC, the new PEC, is entirely irrelevant, because what the applicants argue is that we had complaints. You promised to deal with those complaints. When it became clear to us through the passage of time that you were not going to fulfill your own undertakings to us, then we decided to sue and institute proceedings in court. And that moment was the moment of induction. And that moment only applies to the complaints subsequent to the conference, not in relation to the conference itself. So we would submit with respect, it's irrelevant for our learned friends to say in their fourth affidavit that you should have come to court because the NEC announced that the provincial conference was held. Because the issue here is what happened to the complaints flowing from the conference.
What provision exists in the ANC constitution for the resolution of complaints post an election? Because if I understand your argument, you contend that the applicant's appeal to the president of the ANC would have given them some hope that their complaints would be resolved.
Yes.
If that is so, then there must be some provision in the constitution for that to be considered.
Yes. What we have relied upon is basically the powers of the NEC, in particular paragraph 12.1. We have not relied on any specific provision in the constitution, but we've relied on the powers of the NEC. And those, Your Lordship, will see from page 241.
The question really is there a provision that will cover
in the
that?
Constitution?
Yes,
No.
the ANC Constitution.
No. No, my lady. What we have relied on is the powers of the NEC as the highest decision-making body,
Yes.
and which is at page 241 to 242. And I would submit, with respect, that
So what provision is being overturned?
well, 12.1, the National Executive Committee is the highest organ of the ANC between national conferences and has the authority to lead the organization subject to provisions of this constitution.
Yes.
And then its powers are then set out in paragraph 12.2.
Yes.
So we would say that that power is broad enough to encompass the determination of any complaints on any matter within the organization. So we would...
If the complaints were found justified, what could it have done?
Yes. We would submit with respect that they would have had the power to either call for a fresh conference or alternatively declare the entire conference as having been unlawful and ask that the provincial conference should hold it again. And this is a point, my Lord.
And that you read into 12.1, you say?
Yes, that we say that if you look at the powers of the NEC, being the highest organ, it would have the power to intervene and call a fresh provincial conference.
See in your heads, you refer in paragraph 17 to an ANC practice.
Yes.
And then in paragraph 19, you refer to the propriety of instituting.
Yes.
Is that something separate and distinct from what you say are implied powers in
Yes.
paragraph 12?
Yes. We have pleaded and practiced that it was part and parcel of the practice of the ANC that if you have a grievance, you are entitled to go to the NEC.
Sorry, where does that appear in the founding affidavit?
My note says pages 1566 to 1567.
1566.
Yes, I will. I'll just,
Founding affidavit.
That's in the reply.
That's in the, yes. I'll just ask for the specific passages. I haven't got the references here. My learned friend is finding it, my Lord, now.
Paragraph 52.2.
Yes. All right. My learned friend will find the specific passages and I'll refer those to the court. So, what we argue here is that the NEC would have had the power to intervene. It did not create any impression that it was not interested in intervening. It created the opposite impression. We would submit that there are also implied powers under the constitution of the ANC, that the ANC in fact would have been entitled to set aside the conference afresh. The last point to be made here is that if one looks at this delay point in its perspective, we would respectfully submit that it's really perverse. The applicants brought these proceedings on the 22nd of July 2016. The respondents filed their answering affidavit only in May 2017, approximately a year Now they come to court and they make two arguments. Firstly, they say you've delayed. Secondly, they say we've taken too many decisions in between. But if I may ask the question rhetorically, who in fact is delaying these proceedings? Is it the party that takes a year to file an answering affidavit, or is it the applicants? So if one really examines this delay point that has been taken, we would say that it's not actually taken in good faith. It's taken with the deliberate intention to delay the proceedings and to cause as much inconvenience to the applicants. Because there is no proper justification given why the answering affidavit took about a year to file. There was a Rule 3512, which we complain is a cynical maneuver on the part of the respondents. But that Rule 3512 was again abandoned. Of course, when the legal representatives changed, we don't accuse our learned friends of being part of the cynical maneuver. But if one looks at this Rule 3512, which is then abandoned, and looks at the fact that the answer is not provided for approximately a year, that very party then comes to court to complain about delay. Then we would submit that the court should not countenance this sort of a cynical abuse of its processes. So, my lord, we would submit with respect that we are not out of time. We are, in fact, within time in proceeding as we did. And to the extent, of course, that PAJA may apply, which we deny it applies, the case is clearly not outside of the 180 days that is limited by PAJA. Could I then move to the third topic, which is the local standard topic? What we understand the argument to be is that because my clients are not branches, quote unquote, they cannot complain in their individual capacity, because the right and entitlement to participate in a provincial conference is a right conferred upon a branch and not upon members. We would submit the argument to be flawed for two reasons. The first is the judgment of Ramakatsa, which is the binding authority that we rely on. That judgment, we've referred to the relevant passage at paragraph 80 of the judgment, at paragraph 24.1 of our heads of argument. Now they explain, Justice Moseneke explains, as in the case of an ordinary contract, if the constitution and rules of a political party like the ANC are breached to the prejudice of certain members, we emphasize certain members, they are entitled to approach a court for relief. So the right, if there has been a violation of the ANC constitution, the right is conferred to individual members. That's the right to approach a court for competent relief. And if one looks at the judgment that is cited by the Constitutional Court as an authority for that proposition, it is the Saunders versus Committee of the Johannesburg Stock Exchange. That makes the proposition even clearer at page 115, where the learned judge finds there is no doubt that rules and regulations of a body like the Stock Exchange, just like the rules and regulations of an ordinary club or the articles of association of a company, constitute a contract between its members. And that is the reason why any particular member, if the contract is broken to his disadvantage, has the right to come to the court for appropriate remedy. So we know from Ramakatsa that any member who feels aggrieved by the decision can approach a court for relief. We also know from the authority cited in Ramakatsa in the Saunders judgment that if a contract is broken to the disadvantage, any particular member can come to court for particular relief. So we would submit that it is not an argument to say that there should have been branches. Any individual member was entitled to complain about a violation of their contractual rights as members. That is also supported, we submit, by the provisions of Section 19 of the Constitution, which is what we refer to in paragraph 27. This is now the second argument. And that argument, that provision confers rights upon citizens. And your lordship will recall, and my lady will recall, that what we are complaining about, we are complaining here qua citizens and qua members. And there can be no dispute that the word citizen, of course, refers to individual and not to branches. So when the complaint is we have been denied the entitlement to participate in the activities of the election of the PEC, that complaint flows from the capacity of my clients qua citizen. It also flows from the capacity of my clients, Kwa members, and in both of those capacities, they are entitled to come to court. And then finally on that point, my clients have relied on Section 38 of the Constitution, and your Lordships and my lady will know the section. There's no need for me to refer to it. But the point is that authorities that have interpreted Section 38 of the Constitution make it clear that a generous approach, a wide approach to standing, ought to be preferred. And here we assert a Section 19 claim, and the court doesn't have to make a finding on Section 19 to decide whether or not we have standing. Standing, in a sense, is a question to be decided on an anterior basis, and there's ample authority for the proposition, and it's trite. So we've referred only to Kruger versus the President of the Republic of South Africa, particularly in paragraph 21 to 23. They assert a proposition that has now become trite, that when a court is engaged with questions of standing, it must adopt a wide and generous interpretation to standing.
Do you draw any distinction between whether you're relying on the alleged non-compliance with paragraph 17.2.1 of the Constitution and the other leg of the applicant's case dealing with the so-called irregularities where branches were denied or allegedly denied certain involvement in the provincial conference for the purposes of locus standi?
I will submit with respect, my Lord, that there should be no distinction. It should be, a member should be entitled to say that my branch was denied X rights, but that denial also applies to that particular member, Kwa member of the ANC and Kwa citizen. So we would submit that for purposes of standing, any member is entitled, and a different member might disagree. They might say, from where I stand, I have no problem with the way the provincial conference was convened. But that does not take away the entitlement of the aggrieved member from coming to court and setting out what the irregularities were. In fact, we see that on this particular set of facts, and we saw it in Ramakatsa, that other members, of course, the winning group, of course, is always happy with the outcome. But that does not take out the fact that the losing group is entitled to say these are the irregularities. And if these irregularities did not take place, who knows what the outcome could have been. My Lord, you were asking me for the specific references in the replying affidavit. It is at page 1548, paragraph 18.1, where the issue is pleaded, where we say it is correct that there is no formal appeals process. And Justice Chetty was asking me the question about whether there is a formal process. What is pleaded is that there is no formal appeals process available post-election. And then it says, however, post-conference grievances about irregularities and unlawful conduct affecting the conference can certainly be addressed to the NEC, which does have the power to intervene in the face of sustainable evidence thereof. And then they say this is by virtue of Rule 12 of the ANC Constitution, which has been invoked in the past to deal with such situations. And then one example is the setting aside and rerunning at the behest of the NEC of the February 2015 eThekwini Regional Conference, as evidenced by and discussed in the document which I annexed here to marked RA1, which I admit was authored by the present deponent during his tenure as the provincial secretary. The court will note that post-conference grievances are in fact described in that document as appeals. So that is the pleaded point in support of the earlier submissions, that whilst there is no specific provision in the ANC code dealing with appeals post an ANC elective conference, the fact is that the practice in the ANC is to allow these appeals, and the NEC usually intervenes based on its construction of Rule 12 of the ANC Constitution. And this is not a point that is in dispute between our learned friends and I. Thank you, my Lord. Could I then move on to the final substantive point, well, maybe the first substantive point, which is the lack of authority. Now, to start with the basic facts that are common cause, we know that the last elective conference prior to the disputed elective conference was held in May 2012. And we know that that PEC that was elected in that conference would have been entitled to be in office until May 2016. We know that the current conference was held in November 2015, And we know that that was 6 months prior to the lapse of the term of office of the PEC that was elected in May 2012. All of those facts are common cause. What is also common cause is that this conference has been colloquially referred to as an early conference. Also common cause is that this conference was not approved by 30% of the branches. What is disputed is the meaning of Rule 17.2.1. What we submit is that the rule is peremptory, and the rule means that a conference could not be held prematurely unless it had been approved by a third of the branches of the ANC. Our learned friends argue to the contrary, and they say that the 4-year period does not mean that it should lapse prior to a conference being held. So, if those are the common cause facts, and particularly if it is common cause that the clause is a peremptory clause, in other words, non-compliance with that clause should be visited by an order setting aside the entire conference. In fact, in the answering affidavit, there is a specific reference by the applicants. They say that it's potentially fatal. So if we are right on the interpretation of Clause 17, it's important to emphasize that it is dispositive of the entire case. It will in fact not be necessary for the court to look at any other irregularity, because this particular conference would not have been held consistently with a prescribed provision in the Constitution. So what does it mean? So we know, and this is trite, we know from the Endumeni judgment, you look at the words, you look at the context, and you look at the purpose. And then sometimes the words will be more important than the context, and sometimes the context will be more important than the words, and then sometimes the purpose will be dominant. So we start with the actual words, and this is at page 246, where the Constitution appears, and it's under the heading Provincial Conference. And 17.21 tells us that the Provincial Conference shall be held at least once every 4 years, and more often, if requested by at least 1/3 of all branches. The question then is, what does this mean? We've taken the view that in its language, what this means is that there should be a period of 4 years must lapse before the next conference can be held. Why we say that? We say that you must look at that provision in the context of Clause 17 as a whole. If you look at 17.3, which is at page 247, what we know about the role of the Provincial Conference, particularly 17.33, one of the things that are obligatory that a Provincial Conference must do is to elect the Provincial Chairperson, the Deputy Chairperson, the Secretary, Deputy Secretary, Treasurer, and the additional members. And look at what it says thereafter of the Provincial Executive Committee, who will hold office for 4 years. The Provincial Secretary shall be a full-time functionary of the organization. And then, of course, there are other peremptory provisions. So you look at 17.21 and you look at 17.33. What are you left with? You are left with two things. Is that 4-year period is not a period in the air. It is a period whose purpose is to prescribe the term of office of the elected Provincial Executive Committee. Because it's quite plain from 17.33 that once elected, you must hold office for 4 years.
Yes, sorry, Mr. Mnogoto. If you look at 17.33, it says who will hold office for 4 years.
Yes.
It doesn't say who will hold office for not less than 4 years.
Yes. 4 years would set the minimum, because it says they will hold office for 4 years. So that's the minimum. And if they wanted to say it should have been more than 4 years, or it should have been less than 4 years, but 4 years is the minimum, because they must hold office for 4 years. After 4 years, they must leave. Sorry, I'm not sure if I get the question, Justice Chetty. I don't want to miss the point.
The point that, if I understand you correctly, is that you contend that if you look at 17.21,
Yes,
it must be read in conjunction with 1733.
Indeed, correct.
And if I understand you correctly, you say that the conference must be held within or not later than 4 years.
No, I submit, it is our learned friends who say that it must be held, it can be held within. I submit that a 4-year period must lapse prior to the conference being held, because the purpose of holding a conference, among others, is to elect the leadership. In fact, it's an obligatory requirement. It is to elect the leadership. Once that leadership is elected, another obligatory requirement, peremptory requirement, is that it must hold office for 4 years, minimum 4 years. If one took the view that has been advocated by our learned friends, it then becomes clear that you will frustrate the provisions of 17.33, because it would mean that the elected provincial executive committee will not hold office for 4 years. It will in fact hold office for a period less than 4 years. Yet 4 years is in fact the minimum that the provincial elected executive can hold office. So you have to look at 17.21. There must be a conference every 4 years. 17.33, that conference must elect a leadership that must hold office for 4 years. So what's clear from those two provisions is that the dominant purpose behind clause 17.21 is to prescribe a term of office for the elected leadership. And that term of office, we know what it is 4 years, not less than 4 years.
But 17.33 must be subject to 17.21. If there's a properly elected, let's call it early provincial conference, at the request of 30% of the branches,
yes,
then clearly it can't be a 4-year. They can't insist on a 4-year term.
Precisely.
It would then be whatever lesser term there is.
Precisely. And this is correct. There is now an exception. And that exception is in clause 17.21 itself. If you want to deprive the elected leadership of the entitlement to serve 4 years, that deprivation can take place only under 17.21. And that is more often if requested by at least 1/3 of all branches in the province. So what the branches can then do is to say that we have elected you, you are entitled to be in office for 4 years, but we want to cut short your term of office because we don't like your decisions. If you have 30% of those branches making that determination, they can collapse the PEC and re-elect a new PEC. Now that is on a proper coherent reading of the Constitution, is that the default position is that you hold your conference in 4 years, you elect a leadership, that leadership is entitled to be in office for 4 years. You want to depart from it, and this is the exception from the default position, you want to depart from it, you can do so only if you have 1/3 of the branches making that request.
So if I can just...
If we have another interpretation of this, and I think the point has been raised, is that more often this wasn't an additional, it was just an early conference. So it's not an additional conference where it's more often than what was expected.
No, it is once. So once every 4 years, but you may have it twice within 4 years.
Yes, but this was the next conference. It wasn't going to be an additional to the next one. The next one would have been the 8th, but this was just the next one. So it wasn't an extra one where we would be having 9 and this was 8 in between.
Yes, yes, that is true. The point of the interpretation at least is, I'll deal with the facts of this particular case, but the point of the interpretation is that the conference is once every 4 years.
Yeah.
If you want to hold it twice every 4 years, then you need this permission.
Yes, so, but there's no indication that this was going to be held twice.
Yes, but if one looks back at 2012, so you have that conference once, that 4 years must lapse. What they've now done is to actually hold it twice prior to the lapse of that 4-year period.
But there is nothing on the papers to indicate it was twice. On the papers, and it is common cause, it was early, and there was a reason for that because the local elections were going to take place.
Precisely, yes.
So really it's an interpretation there of more often.
Precisely, we accept that entirely. What we submit is that properly construed, when it says once every 4 years, what's quite clear is that from May 2012 up to May 2016, that 4-year period should have lapsed. What they then did is, in fact, to hold it twice within the 4-year period of May 2012 to May 2016, because they held a conference in May 2012, and then they had another conference in November 2015. They could do so only if it had been requested by a third of the branches. Because there may be many, many instances, as you point out, my lady, that would necessitate.
Sorry, just a moment. I think if people can stop whispering in the court, it is distracting due to the acoustics in this court, and I think it does throw counsel off track as well.
Thank you, my lady. I thought there was a question coming from Justice.
Yes.
Yes.
Just so that I understand you, you mentioned earlier that 1/3 of the branches could collapse.
The PEC, the elected PEC.
Not necessarily so, because if one reads 1721, 1/3 of the branches, their support would be necessary to call an early conference.
And then the outcome would then be determined at the conference itself. Yes. This is the correct phraseology. You're right. The correct phraseology is that they could call for an early conference, and at that early conference there could then be a collapse. Alternatively, they could be affirmed.
Yes.
But what this case is about is, at the very beginning, is whether or not they were authorized to begin with to hold the provincial conference. What we submit, and I think the leadership presiding has got the finger on the problem. What we submit here is what authority existed to hold this conference twice between the period May 2012 and the period May 2016. There is no such authority, because the only authority that could have existed is the authority of a third of the branches. It is common cause here that there were no such branches that called the meeting at all. It is common cause that this was a decision taken by the Provincial Executive Committee itself, and as the leadership presiding points out, the justification for it was that because there are local government elections about to take place. Justification aside, the point of the matter is that they never complied with their own constitution in convening this elective conference. So we submit that the starting point is to recognize what is the point of this 4-year period in order to understand whether there can be 1 or 2 within a period of 4 years. The correct way of construing it is to look at Clause 17 in its totality. What we know about Clause 17 in its totality is that the 4-year period is not a period that stands in the air. It is a period specifically designed to define the term of office of an elected leadership. That does not mean that there are no exigencies where that term of office needs to be restricted or the conference needs to be held earlier. There may be, as we know in this case. However, the peremptory requirement is that that should be a decision of a third of the branches. In fact, your lordships will have seen, and my lady, will have seen from the 4th set of affidavits in Annexure SA1, which is a report of the ANC of the 27th and 28th of May 2015. Unfortunately, unfortunately, this is not numbered, but in the 3rd page of SA1.
Mpumalanga experience.
Yes, precisely. What your lordship would have seen is a very curious fact, which actually comes from the respondents themselves. The ANC in Mpumalanga will be holding an early conference as decided by 1/3 of its branches at its Provincial General Council held in May 2015. The NEC congratulated the newly elected leadership of the ANC in KwaZulu-Natal. And of course, what our learned friends wanted to draw our attention to is that sentence. But the earlier statement is a powerful statement that illustrates that even the practice within the ANC itself is that if you want to call a conference earlier than the 4-year period, there must be a third of the branches approving it.
Well, they've also referred to other experiences where it's happened in the past,
yes.
After 3 years,
yes.
without apparently branches requesting it.
Yes.
But is that really relevant?
No, it's not.
It's a question of interpretation. If it was incorrectly applied in the past,
yes.
it doesn't change the decision we have to make.
Precisely.
Can I just ask you something else? On your interpretation of Clause 17.2.1,
yes.
you've stressed the fact that it's May 2012 to May 2016. But doesn't that clause just simply mean that you have your first conference, hypothetically, in 2012, And if you have to have one 4 years later, you must have it in 2016. But you could have had the first one at the end of 2012, and you might have the second one 4 years later, earlier in the year in 2016.
Yes, well,
why is it necessarily that a full calendar year calculation of 4 years need to have expired?
Well,
why is it not like the sporting codes?
Yes.
Like if you have the World Cup soccer here in 2010, then the next one is, what is it, 2014?
Yes.
But sometime in 2014, not... We had it in 2010 here in, what is it, July?
Yes.
It was in the winter time, July,
yes.
August.
Yes.
So the next one, if it's held in the northern hemisphere, it might be more convenient to hold it earlier in the year.
Yes.
And isn't that what this clause refers to?
So we would submit that would not be consistent with the fact that you are entitled to hold office for 4 years. Because we would submit that when it refers to year, it must be construed to mean 12 months rather than a calendar year. To have it the way that Your Lordship is putting to me would ultimately defeat the very point of entitling a PEC to hold office for 4 years, because it would simply mean the PEC is in fact not entitled to hold office for 4 years. In fact, it might have another adverse consequence that we will submit with respect, that you would in fact never be able to tell what the term of office is, because it could be anything between January and December.
See, it wasn't specifically argued in Ramakatsa, but if you look at the judgment of Moseneke, DCJ and Jafta J at page paragraph 86, he comments, and it came quite naturally, the 4-year term of the PEC was due to expire during the course of 2012.
Yes.
Having previously said in paragraph 85, during 2008 and at the town of Parys, the previous conference was held.
Yes,
so you accept that it's 2012, somewhere in 2012.
And he doesn't specify the actual month.
No.
But Your Lordship must look at paragraph 84 as well of that judgment, which says the provincial conference elects the PEC, which holds office for 4 years. And then once elected, it becomes then the highest...
but it takes me back to my earlier point, subject to 17.2.1.
Yes.
If an earlier conference is called, yes, then nobody can insist, well, I'm entitled to remain in office for 4 years.
No, indeed, my Lord.
So,
yes,
if it so happens that you're there for 3 years and 9 months,
yes, yes,
part of the political process.
Indeed, my Lord. The legal way of resolving it is to work out the default position, which we say the default position is clearly 4 years. And 4 years must be an entire period of 4 years, because it must be functional. I mean, as prescribed in Endumeni, it must be functional because you have to be able to define the term of office. And it will simply be dysfunctional to say a term of office can be anything between January and December. So once you worked out the default position, which is it is a period of 4 years, then what is the exception? 17.2.1 then tells us what the exception is. The exception is we can cut your period, but we can do so only if it is a third of the branches that have made that determination. And we come back to the facts of this case. We know that we have no such a decision by a third of the branches. Now, there is something else vital about this point that we've just debated with Justice Kuhn, which is the question of the location of power. If our opponents are right, that the PEC, and this is what happened here, the PEC decided that it must hold the conference earlier for whatever reasons that it had. If that is right, what that does, it enables the PEC to decide for itself what its term of office ought to be. But the term of office is prescribed in the Constitution. The PEC itself is not entitled to decide that we are now going to be in office for less than the elected period, because the PEC is not serving itself. It is serving a mandate that emanates from the branches. You know, the ANC people like singing the song, Amanda Semasebeni. It's important because it shows an important constitutional point, that it is in fact the branches that give rise to an elected structure, which is the PEC. But it's also important because it means that the PEC should not be deciding what its own authority ought to be. That authority comes from two spots. It comes firstly from the Constitution. You must be there for 4 years, whether you like it or not. If you want to resign, you can resign. But we may short-circuit it. But again, it is the branches that might short-circuit that period of 4 years of the branches. If the court allows this sort of interpretation to prevail, what it means is to extinguish the power of the branches, which are the key constituent element in relation to the provincial conference, which are the ones deciding who must be elected and who must not be elected, and which are the ones deciding what the term of office ought to be because of the power that they might exercise under 17.21. So not only do we have a clause whose clear purpose is to define a term of office, we also have the other problem that if this construction prevails, ultimately any PEC can, after 1 year of holding office, decide, well, we no longer want to do this, we're going to call an early conference. But that simply is not allowed. If that is what the ANC wanted to do, it would have given that power to the PEC. In fact, the PEC has no such power at all in terms of its own constitution.
So your submission is that if an early conference is to be called or was to be called, it could only have been done in accordance with 17.21.
Precisely.
Branches.
Precisely. And this is the point of distinction between us and them, is that if they wanted to do 2 conferences within that 4-year period of 2012 to 2016, then the branches should have sanctioned it. A third of the branches should have sanctioned it. That failure was then fatal because they never actually complied with it. Justice Kuhn, I don't want to leave the point that was actually helpful in the exchange I had with you, because when you say, well, what about a year? I mean, what do we know about these facts? 2012 and 2015.
No. It doesn't assist.
Yes.
It's just at the level of what you postulated.
Yes.
Because even if the construction I suggested to you is the correct one, then it was still, quote, early, unquote, by, 7 weeks?
By, by...
It could then earliest have been held in January of 2016.
Precisely.
Yes.
It is still invalid for the very same reasons.
Can I just ask you something else, just for my own edification? This request by the branches, 1/3, who must that request be made to? Which is the body? Is it to the PEC? Because the PEC, we know on the facts here, decided on the earlier conference, and then there was some approval to be obtained, it looks to me, from the NEC.
Yes.
Then the Secretary General wasn't happy at the end of, where was it, October 2015.
Yes.
And there was a sort of a temporary, I call it a moratorium. It stalled, and then it resumed again. Who's the body, or where does this, who's got the power to decide when the PC, the provincial conference, is to be held, and to whom would such a request by 1/3 of the branches be made?
Yes. Well, what we know on these facts at least is that in relation to Mpumalanga, that was taken at the Provincial General Council. So there seems to have been a Provincial General Council taken there. But we would submit here that whether the request is sent to the PEC or whether the request is sent to the NEC, the key issue is that it must be a decision of 1/3 of those branches.
The Constitution is silent on that aspect?
Yes, because there is no provision specific on that issue.
Yes.
Now,
before you proceed, unless you're finishing off a point, we will take the short adjournment, or do you want to finish your point?
No, I'm happy to take a short adjournment, my lady.
So we will take a 15-minute short.
Thank you, my lady. whenever they assess the vital point. Yeah, but 2 points to make.
We have a private body. Where's the legislation? So it must be. Otherwise they would have said the terms of any law. What do you say at this point of view?
The only thing I was looking for now is whether there's anything again there's nothing in the legislation as well. So when I was trying to answer points from so because he says that because I don't want to decide this issue and this means everything is done yeah. You must work on the basis that the year's purpose of the starts from the time starts from May. Thank you, my lady. So I was still concluding my exchange with Justice Kuhn in relation to the year. There are only 2 points to be made. We've now looked at the Interpretation Act. It doesn't define a year, it defines a month. And we've looked also at some criminal law cases, especially in the sentencing context, where a court says you are sentenced to 3 years imprisonment. It doesn't start, you don't get suspended now until the 1st of January. The year starts counting on the day you hand yourself in to the police, and that's the general context. We will find those cases and hand them up to the court.
I don't think you need to hand me cases on the criminal context.
Yes,
That's clearly different.
Yes. So I'm talking about the other cases that deal with the calculation of a year. So the only judicial context that we see the year being used is the criminal context. Not that there are any criminals in court. And then the one more point to be made about this is the potential superfluity of the use of those words 4 years. When the Constitution says 4 years, those words must be given effect. If our learned friends were right, that would simply mean that when the Constitution refers to 4 years in 2 contexts, in 1721 and in 1733, actually that 4 years shouldn't be taken seriously, because it could be anything from a month up to that period of 4 years. But in order to take seriously the use of the word, of those terms, 4 years, it must mean a minimum period of 4 years. And then the exception being per demand of the branches, it can be called earlier. So could I then leave this point, if there are no further questions from the bench, in relation to the meaning of 17.21 and 17.33. We have made 3 submissions, if I may summarize them. The first is the default position is that the purpose is to elect a PEC that must serve office for 4 years. There is an exception to that default position, which is a request by branches, a third of the branches. On the fact that it is common cause, there was no such a request, and the natural consequence of that is to vitiate the conference. Could I then move on to the last question, which is the question of remedy? So if your lordships are with us that we are right in the way that we have construed 17.21 and 17.33, what should happen next? We submit, and we deal with this in page 19 from paragraph 45 onwards. We submit that we've cited the case there of Matlolo versus Mahuma. It's a judgment of the Supreme Court of Appeal dealing with, I think the party there was the United Christian Democratic Party. But the point that was made in that party, is that, in that case, is that a political party, which is a voluntary association, is obviously bound by the strictures of its own constitution. And where it does not comply with its own constitution, the correct remedy to be issued by a court of law is to set aside the non-compliant decision. Now, the point is to be made specifically in this context, because we see in the answering affidavit of the respondents, and I think this is the point they also take up in their heads of argument, that there is some kind of a residual discretion that a court might exercise pursuant to section 172 of the Constitution. We would submit that there is no such a discretion to preserve the unconstitutionality of the conference. In other words, you should nevertheless, even if you find that it was unconstitutionally held, but you will have a discretion to preserve it or preserve the decision taken pursuant to the conference. We would submit that if there is no compliance and the non-compliance is a material non-compliance, then there is no discretion. The order is clear. The entire conference and the resolutions taken at that conference and the election of the PEC in that conference should be set aside. This was a point debated at some length in the Ramakatsa judgment. What Justice Museneke ultimately decided was that 61. So if your lordships will, this is a bundle of authorities by the respondents, and your lordships will see the references to the remedy from paragraph 121 at page 76. And particularly paragraph 124. This is the ultimate point made by Justice Museneke. in our view, a declaration that the provincial elective conference of the ANC and the decisions taken at the conference are unlawful and void should suffice. And then they say it applies only to the provincial conference. And then it does not affect the rights of the delegates who have been elected properly constituted branch general meetings of the Free State Province to serve as delegates at any other conference or the party. We will confine our remedy only to the first part, which is merely a declaration that the election and the decisions taken therein are unlawful and void. And that would apply only to the provincial conference. That we submit should take care of the subsequent complaint by the respondents, where they say we have been in office for so long and we have made several decisions on the basis that because we were elected, the election was a lawful election, because it would not attack the decisions that they have taken post their election. And your lordships and my lady, you will find authority for that proposition in the Simelane case, which we cite in paragraph 49 of our heads of argument, and the de Kock case. And your lordships remember the facts of the Simelane case. Mr. Simelane is appointed unconstitutionally, but he is the head of the NDPP and he takes several decisions. The case then comes before the Constitutional Court 2 years after his appointment. The question arises, what happens to all the decisions he took after the unconstitutional election? And Justice Yakub finds that in these circumstances, we should make an order that the invalidity of Mr. Simelane's appointment will not by itself affect the validity of any of the decisions taken by him while in office as the National Director. This will mean that all decisions made by him remain challengeable on any ground other than the circumstance that his appointment was invalid. The same principle applies in that case of de Kock versus Van Rooyen, but the facts are slightly different. What happens here is magistrates are appointed in conflict with the Constitution because the Constitutional Court subsequently finds that the statute that allowed the appointment of acting magistrates was unconstitutional. The question then arises, what happens to decisions taken by those judicial officers who subsequently were found to have been elected, to have been appointed unconstitutionally? The judgment by Justice Cameron is quite clear on the point. Those decisions remain valid. Anybody can attack them, but they must be attacked on their own merits. So we submit here that the question of remedy is absolutely important because we are asking for a very, very limited form of relief. And there will be no Armageddon if the court grants the relief that we ask. All that simply will happen is that the provincial conference will be rerun. But everything else that has happened to the provincial conference will remain intact. So we submit that the court should not, with respect, be impressed by the argument of the respondents that a lot of water has gone under the bridge. This does not prevent this court from issuing a declaratory order correcting the unconstitutionality in the conference. Yes. Yes, that takes me to the end of the points I was meant to make. Thank you, and thank you, my left.
Handing up your bundle of authority so that we could use it.
Yes, my lord, my lady. I may hand these up.
Thank you.
Thank you, my lady.
Have you prepared other heads or are we using the existing ones?
There is a case by in the case of August, but it's referred to August versus Electoral Commission.
So
it's referred to in the case of Ramatal.
Are we using the original head?
Yes, the what?
Mr. Hunt's.
Mr. Hunt's head.
Oh, the head's argument?
Yeah.
No. We use the original head.
Original, okay.
August. This is Electoral Commission. Sorry,
referring us to the main heads.
Yes, my lady, but I believe that it would be useful to preface our argument by asserting that this case implicates the applicant's right to make political choices as described in section 29, including the right to stand for public office. And this has been confirmed and affirmed in the case of Ramatara. And because the case implicates those constitutional rights, we submit that it is necessary to establish the proper approach to some of the issues which pertain to the irregularities which we want to address at this stage of our argument. And that approach is one that was given by a Canadian judge in Hague versus Canada, a judgment which is quoted in August, which I've just handed up to you, at paragraph 17.
How many bundles? No.
1993. Where the Canadian judge says every reasonable effort should be made to enfranchise citizens.
So just a moment, we don't need the 3 extra copies. Your 6 copies had the doc.
It's August.
Yeah.
Which paragraph?
Sorry, what paragraph are you reading?
Paragraph 17.
17.
Madam Sarah.
On page 23.
Yeah, just carries on and on.
Yeah,
With the
just
photo.
there's a couple there.
Quotation, yeah? And that conversely every care should be taken to guard against disenfranchisement. The reason why we cite this dictum is because in this case it assumes some significance in the context of the argument which has been made by the respondents in relation to what has been referred to in respondent's head of argument, the 70% rule, which has been used by the respondents or invoked by the respondents to negate the applicants or the ANC branch membership's right to participate in the processes leading up to the conference, which is the subject matter of this case. The interpretation of the 70% rule, which in our submission, though incorrect, stands in stark contrast with the injunction which appears from the Canadian judge's instruction, which I have just referred to. Before, I will illustrate that when I deal with the irregularities themselves later, maybe I should just, in broad terms, indicate what topics of irregularities we wish to address in our argument. There are 3 in all. First are the irregularities dealing with the termination of branch membership role. And we address under that topic 2 issues. First, what is referred to as the pre-audit stage of members of the branches in preparation for a conference. The case there being whether the branches were given access to the pre-audits before they were audited by the national, or were affirmed or confirmed by the conference. The second aspect is what has been referred to as the audit stage. At that level of the argument, we will advance the argument that the branches were not given an opportunity to appeal against the final audit. And the result of all that was that a number of branches and a number of members in those branches were excluded from participating in the conference. The second category of the irregularities relates to the accreditation of delegates in what has been referred to in the papers as the credentials report. We make 2 arguments under that topic. we say that the adoption of the credentials report, once the appeals were underway, was irregular. And we will demonstrate that with reference to the record. And we also say that the failure in the accreditation or the adoption of the credentials report involved the failure to include branches whose appeals had succeeded during the conference there. And we demonstrate that with reference to the documents which we referred to. And then finally, under the third broad category, we will deal with the voting process. The tweet, and we will make the point about that, the elections were predetermined. It's clear from what has happened during the voting process.
Sorry, Mr. Martin, sir.
And that...
I'm sorry. You make these submissions on the basis that all of these irregularities meet the evidence test.
Yes, I will
understand you correctly.
I will deal with them on the basis that to the extent that there are dispute of facts, we will try and shy away from issues where there are dispute and confine ourselves to those matters which, on the basis of the facts which are asserted by the respondents, the court is at large to grant the orders which we see.
Yes, but we're quite clear from the papers what are in dispute, especially on the question of the tweets. There is a dispute on that. So you're raising this as one of the irregularities.
I will deal with it at that level, because I will show that even though there is a dispute insofar as that is concerned, it is a fanciful dispute that the court is entitled to reject on the test that is established in plus and evils. I'll make that point later in the argument. Later, I'll come back to it. The convenient starting point is, of course, to deal with the argument which relates to the 70% argument. I deal with that argument separately from the other irregularities, because as the court would have seen in the arguments made by the respondents, this 70% rule, as it is called, keeps on coming up as an explanation, or to explain away some of the irregularities. It's been said that even though there could be some other irregularities in relation to the accreditation of the branches, that is not something that is fatal to the process, because 70% of the entire membership of the ANC in the province qualified, or rather complied, and therefore the court should then overlook those irregularities, as we understand the argument. In other words, the essence of the respondents' contentions about the 70% rule, which, my lord, appears from a document which is entitled document LD5 at page 353, relating to pre-conference processes. This document, my lady and your lord, is a document prepared by the then Provincial Secretary, Mr. Sihle Zigalala. It is entitled, "What Constitutes a Legitimate ANC Conference?" At page 353, item 1, it deals with the time frames, and it says time frames must be set towards the conference. These time frames.
This document is an interpretation.
It's an explanatory memorandum.
Explanation and interpretation. It's not a rule as such.
And I raise it because it's been raised by the respondents as a defense
just for clarity.
It is, yes. These time frames should be taken into account. These time frames should take into account the following sub-processes. And under the last bullet point, it says 70% qualifying branches in bracket minimum. The interpretation which emerges from the argument advanced by the respondents is that, well, if there is qualifying, the 70% of the branch is qualifying, you can live with the problem relating to the other 30%, but you still can go on with the conference. That notwithstanding, as we understand the argument. And that argument is actually advanced to defeat certain assertions which we make about certain particular irregularities which occurred at various stages of conference preparation. We say that that interpretation of the clause of that document cannot hold because it misconstrues the purpose for which the explanatory memorandum said. What the 70% qualifying branches minimum is supposed to regulate is to allow, is to give guidance to branches when preparing for a conference to attend conference or the conference to be held where at least a minimum of 70 people have qualified. In other words, if there are difficulties with other branches qualifying, you can still go on only if you have 75%. In other words, you can't go on with the conference unless there's at least 75% minimum. But that is not the maximum, that's not the goal. The goal is to have everybody else participating in the conference. But if there are problems, you can always go ahead with the others, the 70% being there. It is a critical mass that is required for a conference to be held. It cannot, we submit, that interpretation given to prohibit. It cannot be used to exclude legitimately qualified branches who fall within the 30% grant. So in our submission, we say that there is no substance in the argument that this provision, the 70% qualifying, the 70% rule, can stand in the way of the court dealing with irregularities which are patently clear from the documents, simply because the people who raise those complaints fall within the 30% grant.
In essence, what you're saying is that all the branches must have been given an opportunity qualitatively to qualify.
Yes.
An adequate opportunity.
Exactly.
And that presupposes any application of the 70% rule.
Yes.
If they've all been given an opportunity to qualify, but for some technical reasons or otherwise, some don't qualify, provided you've got 70%, the provincial conference can go ahead.
You can go ahead.
That's it in a nutshell.
That's in a nutshell.
Yeah, okay.
Mr. Madansela, that would almost constitute a quorum for the meeting to proceed.
Yes. So there is really no substance in the argument. It does not stand in the way of the court dealing with the irregularities if they exist, as we shall show. In dealing with the irregularities themselves, we submit, my lady and the lordships, that the genesis of the problem which has led to the irregularities was really at the start of the process that was set in motion to prepare for the conference. In the heads of argument, or rather in the practice note, we set out at page 8 onward a chronology of events that chronicle the timelines which were set in motion in order to allow for preparation of the conference. These timelines reflect the chopping and changing and stop and go in the preparatory steps towards the conference. You'll see that whilst initially the timelines were set out in March, leading to a conference which was at that stage set out for the 25th of September 27. I'm referring now in paragraph C at page 9 of the chronology. On the 23rd of August, that decision was changed to provide for different timelines which are set out in paragraph E of the chronology. The second set of timelines which were given in our submission were two truncated timelines. So much truncated that in our view they really conduced to a situation where the conference, which was now to be held on the 6th to the 8th of November, was simply a farce, as it ultimately was in our submission. 2 months was given from September to November to prepare for the conference. But not only that, in the process, or in the middle of that timeline, on the 2nd of November, as we see at paragraph H at page 11 of the chronology, the Secretary General at paragraph G put a stop yes, on the 27th of October, put a stop to the flow of that timeline and said there was not going to be a conference, only to change his mind a week thereafter on the 2nd of November. So this chopping and changing of and stop and go in the roadmap for the preparation of a conference had the knock-on result that the conference became a shambles, as we were told, in the irregularities which occurred along the way.
The fact that the timeline became truncated is not an irregularity on its own. It's an inconvenience maybe.
Yes.
But are you going to take us to provisions that were specifically not complied with?
Yes. What needs to be done for the preparation of a conference requires consideration of a number of rules in the guidelines of the ANC. But I propose to refer the Lordship to the judgment of Ramakata at paragraph 77, because that case tabulates, in a sense, the flow of events that should follow in preparation for the conference. That process includes the following things. Paragraph 7, that the PEC must determine the cut-off date for purposes of conducting an audit process, and then the national audit team must then verify paid-up numbers of each branch, and then determine the branches which are in good standing, and then after the completion of the audit, the audit team must then submit a copy of the preliminary audit report to the relevant provincial secretary. And the audited branches are afforded 5 days from the finalization of the audit within which to raise queries, and for the audit team to respond thereafter and make corrections to the preliminary report. And only then is the issue of accreditation final, and the decisions of the PEC and the RSC on that issue become the final arbiter in relation to the corrective. There, in that process, set out in that judgment, lies in manifold irregularities which occurred. The starting point in the examination of these issues is to deal with the first category of irregularities, is to look at the founding affidavit at page 75 to 78, where at paragraph 107 to 113, a complaint is made by the applicants that there was failure to furnish branch general meetings with the voters' roll 2 weeks before the meetings of the, as recommended by the ANC document. And my lady and your lordship, I take you back to LD5, which is a document prepared by the provincial secretary at the time, and refer you to pages 354. This document, as my lady has asked me previously, reflects the provincial secretary's understanding of what constitutes a legitimate ANC conflict. And he sets it out in the last column, or the third column on the right-hand side, where he says branches should be given membership roll 2 weeks before the meeting, the BGM date, to ensure all members have been correctly captured. Well, if you look at the timelines which were issued, and I will use, for purposes of our argument, the latest of the timelines which were issued on the 6th of September, because those are the timelines which regulate the process going forward. Those are found at page 422 as Annexure LD 16 to the founding affidavit. And they're pretty much common cause, and they're referred to in the chronology which I referred to earlier. The truncated timeline.
Sorry, 422?
Page 422, LD 16.
The LD 16 is at page 402. 402.
402. I'm sorry, my lord.
My copy.
I may have made a mistake about my notes. Yes.
Yeah.
The timelines there given to allow branches to effect corrections and improve their status was set to be the 10th of September 2015. Giving the branches barely 4 days to do anything about the role. This is what has been called, my lord, in the papers, is the pre-audit stage, so that branches can meet with the auditors and then assess what they intend to put up as the role, and then make corrections before they take it up to the National Audit Committee, National Audit Team. What you see, my lady and my lord, at the answering affidavit at page 1075, that's file 3, paragraph 32, is an answer to the complaint about this irregularity. The answer given to the irregularity does not dispute that the document LD5, or the guidance provided by it, required or prescribed or recommended that 2 weeks be given to the branches to deal with this, with the corrections. Rather than dealing with that key issue, the answer seeks to rationalize about why that requirement was not important and could be overlooked. Quite enigmatically, Mr. Zigalala, who is, by the way, the author of LD5, turns around and says, well, I made that recommendation, but I really didn't mean it, because people can ignore it. It's just a recommendation, it's not mandatory. Now, why make a recommendation? We ask the question, if you are not going to insist on its adherence. But the argument in the answering affidavit misses the point altogether, because by pointing out that irregularity in not following the recommendation which Mr. Zigalala gave, We are not trying to enforce the recommendation. We are pointing out that it was not followed, and no reasons were given for not following it. That's the issue. That the ANC will determine what it considers to be a legitimate conference by doing all of these things, giving members 2 weeks before, and then turn around and says, we don't have to agree with it. It points to the fact that the process that was given for the preparation of the conference was so truncated that some of the recommendations which the ANC had made for itself, the rules that they have made for themselves, the recommended for themselves, could not even be complied with. So then, my lady, if we look at the matter from that perspective, one sees that the timelines which were given by the province for the preparation on the branch, at branch level for the conference did not offer branches and members in the branches any wiggle room to maneuver in preparation to deal particularly with the audit and to set its house in order to prepare for the delegates to represent them at the provincial conference. We say this is an irregularity of its own, which entitles the court to grant the relief on the basis that there was no compliance with the recommendations by the ANC itself. There are disputes of fact which then arise, which relate to the matters which are dealt with at paragraph 75 regarding the Ndalabantu branch and some kind of branch at paragraph 1110, as well as some kind of branch, and something that happened at Bears Node branch, paragraph 112 at page 77. But all of those disputes about whether the voters' roll was given to the branch secretaries before the meeting, those disputes pale into insignificance. In fact, they are not material to the core issue about which you complain. That the timelines for doing all of these things, had there been enough time given to the branches, branches would have been able to sort out these very disputes which have arisen. And that is the key or the kernel of our complaint. The time was not given for the branches to properly prepare themselves in order that they can settle their disputes, which have now arisen in these papers, in a manner that allowed them to prepare for the conference going forward. That is, in a nutshell, the kernel of our such complaint and irregularity in the process.
But all of that presupposes that the 2 weeks is a prescription, a rule.
Well,
and your authority for saying that it is, I understand you take it from Annexure LD5 at page 354.
Yes. And,
now, why that document says, sorry to interrupt you, tabulated hereunder are certain procedural challenges that might be encountered. It is recommended that if the following primary principles are adhered to, then such challenges may be averted. And it's in that table that then follows that this 2 weeks appears. Isn't that just a recommendation? Why do you say that if you're 1 day short on the 2 weeks, it's fatal? Also keeping in mind, this is the document that's disputed. Well, they say it's the wrong one. Well, is it not? It should be Annexure S.
There's no dispute about this document.
Okay.
In fact, what Zigalala says about it is that I prepared it.
Yes.
He owns it and says it is his document. He prescribed, he made that recommendation. But the recommendation, we must be viewed against the context that it was made in order to ensure that the conference becomes legitimate. But the question is really, what then if it is not followed? And we say it's an indication that the timelines issued for the preparation of the conference were just not conducive.
I understand that it might not be conducive, but was the 2 weeks a peremptory set limit? No. Which if you're 1 day late, then you're out, that's fatal.
No, we're not saying that it was peremptory. We're saying that the fact that it was not followed, or it was not adhered to, is
as a recommendation.
As a recommendation, is an indication that the conference that followed it was on ANC's own understanding problematic or rather, to put, to put it correctly, fraught with difficulties which Mr. Zigalala foresaw when he prepared this document. As it happened, and I will deal with that later in relation to the other irregularities. We don't rely on it as a standalone, but cumulatively with all other irregularities which we'll point out, it assumes a particular significance in relation to the process that followed. And the next process, which was problematic, was the process of branch membership role itself and the auditing of that of the branch membership. The point which we make at paragraph 113 of the founding affidavit, now this is page 77 to 78, is that the branches were not given adequate opportunity to raise objections or queries or even appeal against the audit report. That's the point. That's the complaint. That's the point we make in those paragraphs. It's dealt with in the answering affidavit at page 1082. My lady and my lords, may I just I've just moved ahead my time. I promised that there is a spreadsheet that has been prepared for my land famous Richard. It might probably obviate the need to make the notes because the cross references are made in the spreadsheet itself. May I just, with the leave of the court, hand that spreadsheet up because it makes life easy for one to cross-reference. The answering affidavit makes it clear that the preliminary audit were made final on the 3rd to the 4th of November 2015. And this much appears from the credentials report, from the audit report, which appears at SZ7 at pages 112 to 113 of file 4.
Sorry, 11?
1213. Self-stated. And it goes all the way to page 1333.
So on your document, which page are we looking at? The one you just handed
on the
us
spreadsheet.
now, the spreadsheet.
No, that's not in the spreadsheet. It's refers to the annex. But the relevant part of the paragraph is it's page 1082 in the answering affidavit. Where is it?
Yes.
Where so the context of this is that, remember that the 3rd to the 4th of November, it's barely a day or two before the start of the conference. And at file 4, volume 12, we see SZ7 being the verification, the preliminary verification of the branches dated at 1279, dated 3 November 2015. And then signed off by the Secretary General of the ANC, Mr. Pietermaritzburg. And then at page 1291, the second section of that report or audit report is dated by the Deputy Secretary General Jessica Duarte on the 4th of November 2015 in manuscript. So there is no dispute, in fact it's common cause on the respondent's version that the audit of branches was made on the 3rd to the 4th of November. It is then on this footing that one must look at this process against the backdrop of the guidelines, which, as I have indicated with the reference to Ramakat's judgment, requires corrections and appeals to be effected 5 days thereafter before the conference. This was, as my lady and the Lordship know, barely a few days, or in fact 1 or 2 days before the start of the conference, which was due to start on the 6th of November. So we say that because of the truncated timelines, branches were not even given at that stage of the process, given an appropriate and adequate opportunity to pursue their appeals, given that the conference was due to start in a day or two. The result was what, Nabedi? Was then what happened at the adoption of the credentials report, which is the last aspect of our irregularity complaint. And that, what happened is that once there were, of course, as the record shows, very many appeals which were lodged following the audit report by various branches. And I'll take my look to which branches they are at the moment. But there was some jiggling at the conference itself on the 6th and the 7th of November. There was the first credentials report prepared in advance of the conference, which appears at LD 19. But then at the conference itself, there was a one-body counting which excluded some of the people. The result of which was then an updated credentials report which appears at LD 21. But if we look, we should approach the matter from the past and previous perspective and use, for purposes of the argument, the version of the credentials report put up by the respondents appears as SZ15. It is clear that that report was adopted on the 7th of November. And I see, if I may ask the Lord to go to that document itself, it's LD 21. It's actually just the same document at page 544 of file 2.
LD 21.
Yeah. The updated credentials report. LD 21, yes.
So is that the same document that is at 1442? SN 15?
1442?
That's what you referred us to earlier.
Yes, that's the respondent's version.
Yes.
Of the credentials report.
Is it the same document?
It's substantially the same, except that there is, the reason why there's a difference, as I recall, is that it accounted for people who attended.
Okay, so we must refer to your report 544.
After the one body count and the exclusion of those people who were there and those who were not there. But it is for all practical purposes the same document.
Okay.
So we know the complaint that the applicants made at paragraph 114 of the founding affidavit is that the credentials report, which was signed off, as we now know, on the 4th of November, was signed at a time where there were numerous outstanding queries and appeals. And the fact that these appeals were still pending when the report was signed off is confirmed by the report of the appeals committee which dealt with those appeals. You will find that the appeals, the committee report as that 10, file 4 at page 1362. The report details a number of appeals, and I counted 28 wards in eThekwini region only, which are set out in the document itself. And I can name them. The start is very clear. In relation to eThekwini municipality, these are the appeals starting from that page 1362 up to 1374, just eThekwini municipality. And I should underscore at this stage, my lady and my lord, that eThekwini ward, or the wards mentioned here, are the biggest wards in the area of KwaZulu-Natal. And if one looks at the credentials report itself, being LB21, we've counted something like plus or minus 20,000 members from various branches mentioned in this category of the branches. So it's not a small number of people whose appeal was still pending at the time that the audit was signed off. There were other appeals also which were still pending. If you look at paragraph at page 1372, relating to, in particular, the Mtuba ward in the far north region. 5 wards appeals from that area were still outstanding. They are enumerated in that report from 1372 to 1375.
Sorry, Mr. Madansela. And in the right-hand column, from pages 1362 to 1372, is a word often used, this ward was qualified.
Yes.
To understand then those appeals were upheld.
Yes, I will deal with that, because I've extrapolated these statistics or these instances of appeals from a report which was prepared after, which obviously contains the results of those appeals. And I will deal with the results of those appeals in a moment as part of the second aspect of this of the complaint. The point being that in very many places, or in various wards in KwaZulu-Natal, the far north, eThekwini, which is the biggest region, and others, because we know that SZ10 is not a complete document. There are pages missing. Pages missing. And that's besides the point. The point is that quite a number of them were still outstanding, and yet the audit was finalized. The result, how does the respondent deal with this complaint? My lord and my lady will see this at file 3 in the answering affidavit, paragraph 343. At page 1081 to 1091, 15, sorry. What that response consists of is a criticism about the credentials report which has been put up by the applicant, and the criticism is confined to basically saying that, well, all those documents are hearsay. But as I said at the start of this part of the argument, we are prepared to approach this case on the basis of their own credentials report, because it illustrates the irregularity. But what is fundamental about the response is that there is no dispute about the fact that the appeals and queries were still pending when the audit was finalized. Indeed, the appeals committee report, which I've already referred to, confirms this. What then happened, my lady, is that a voter's roll was then created on the strength of the audited report from the branches. In the replying affidavit, we illustrate where the problem was with the creation of the credentials report based on an audit which was finalized at the time when the appeals and queries were still outstanding. We deal with this at pages 1599 in the replying affidavit, being a schedule which has been created to make a comparison between the credentials report put up by the respondents and the final accreditation or the voters' roll, which was then created. The outcome, or basically the punchline of that comparison, is that it illustrates that there were a number of members. You'll find that it's fine. What's the plan? Yes. It enumerates, that document enumerates that a number of members of branches who qualified as a result of the outcomes of the appeal processes did not receive credentials for the conference, and are enumerated at page 1599 in that annexure with a number of people having been left out who qualified, and they are in Roman numeral 1 up to Roman numeral 5 or Roman 7. I exclude in the computation, for purposes of the argument, the issue relating to Ward 57 of eThekwini region, because I accept, insofar as that ward is concerned, there is a dispute of fact. But in relation to those which are enumerated in Roman numeral 2 to Roman 5 and numeral 7, there can be no contest. In fact, if my lady and my lords look at the further affidavit which has been filed by the respondents pursuant to the reply affidavit, this issue is actually not even addressed. It must be taken as having been proven to have been the case for purposes of this argument. Of course, the document over the page, it also enumerates branch members who did not qualify, yet they were also given credentials ultimately at the meeting. Again, insofar as that issue is concerned, there can be no contest. So the upshot of all this is that we make a submission to this court that on the version given by the applicants, which the respondents do not dispute and cannot dispute because documents don't lie, the irregularity relating to the accreditation of branches occurred in circumstances which amount to an irregularity. I believe that there is no authority required for the proposition that if you allow people who did not qualify or disqualify people who should have been there, it should have been there accredited, is an obvious irregularity that distorts the majority of the branches, the voices of the branches. And I do not understand the respondents to be contending that that cannot be an irregularity, because it obviously is. Finally, there was at the end of the conference, during the process of voting, an incident which occurred. And that incident related to the publication of the results midstream the counting of votes. What we do know, the purposes of this exercise, is that voting at the conference took place by secret ballot, as voting normally happens in these days. And so no one would have had any knowledge of what was happening behind the voting boxes when voting was taking place. At paragraph 154 of the founding affidavit, page 100, a point is made, and I think it's not disputed, that the voting started on the 7th of November in the evening and went on until 3 o'clock in the morning of the 4th of the following day. Solomon, it started at 3 a.m. of the 4th until 9 o'clock the following day. Yes, it started on the 7th and finished on the morning of the 8th. Let's put it correctly.
Sorry, where do we see that?
At paragraph 154, paragraph
153.
of the founding affidavit.
15.
So the times are set out in 155.
Yes, the details, paragraph 155.
Okay.
Yes.
But as the amendment make it clear, paragraph 154, is that before even the counting was over, in fact it was still right in the middle of the counting of votes, a tweet whilst the voting was still going on, a tweet came out at about 23 minutes past 10 in the evening and made a prediction about the result of the votes. What is significant for purposes of our argument is what it contained about the votes which were going to be amassed by one of the contenders, Mr. Senzo Mkhulu. It said that he had attained 675 votes. Of course, the answer that is given by the respondents to this at page 1104, paragraph 438, is that this was a fake tweet.
Well, they say that it wasn't entirely accurate.
But that's obviously incorrect, because numbers tell the story. Lo and behold, when the result came the following day, the numbers and the votes which were counted for Mr. Mthuli came out 675 votes. We argue in this case that this was no happenstance. And no one, no matter how prophetic he can be, could have been able to predict the number of votes with such precision as it apparently happened in this case. So therein lies the problem with how the court is going to deal with that dispute of fact. Our submission is that the court is able in these circumstances to say that the dispute which has been created in the answering affidavit is just a fanciful dispute. It cannot be believed. It's uncredible, and it's so far-fetched that the court is entitled to reject it, exercising its robust approach. And the court should find, in relation to the result of the election, that the prediction which appeared from the tweet reflect, in all probability, a predetermined result of the election.
That's a very serious accusation.
It's the honest inference that the court can draw, given the procedure.
You're familiar with cases like Gates versus Gates that says that where there's an imputation of potentially criminal conduct, that's not likely inferred at the level of probability.
Yeah. But the submissions you make at this level is that it's an unreasonable inference. How would anyone would have predicted the number of votes that Mr. Mthuli was going to get, and it happens just like that, unless there was some form of behind-the-scenes machination? That's the only compelling inference that needs to be drawn on the facts in this case. And we ask the court to be robust in this regard, and make that finding for purposes of determining the irregularities. But what makes the matters worse on this aspect is the other part of the process that took place at the conference. In the founding affidavit, we have asked, or the applicants have asked, that the respondent should produce a voter's roll which formed the basis of the voting. The typical answer which has been given is angas, siyaz, shini. Gone lost, missing. How could it have been lost? And why can't it be found in the circumstances which happened after the announcement of the result? We ask the question rhetorically. It is the sort of document that should have been kept, as we say in Zulu, because it was the very basis on which the province was to justify itself, given what happened after the announcement of the result. And the record demonstrates that immediately after the announcement of the result, following day, there was riot in Durban. And there were memoranda given to the provincial office to dispute this very result. It was particularly in those circumstances that the voters' roll should have been kept for purposes of defending whatever case that could ensue as a result of
The explanation is given that the person who conducted the vote on behalf of the Electoral Commission left the employment of that organization.
But the province was the custodian and the owner of that voters' roll. That is an unsatisfactory explanation. Over 2 years now since this litigation has been going on, no explanation whatsoever has been given what has happened to the voters' roll. What steps have been taken to trace that the individual and ask him what the voters' roll is in a matter of such serious contestation. The defense, my lord, in this regard is fanciful, and the irregularity has been proven to submit, and it is an irregularity of the highest order at this level. And if the court is with us then, that these irregularities did in fact occur as we submit the help, then the obvious results are those which have been urged to this court by my learned friend, Mr. Ngoy Toby, that the voting process and the entire process of the conference should be declared invalid and set aside. That is in a nutshell is our argument on irregularities. Unless the court has any questions on any one of them, I have no further submissions.
The timeline referred to by Musineke, DCJ in paragraph 77 of Ramakatsi. Can you just point me to where that appears in the papers in this application as well, please?
Yes.
For example, things such as...
May I just deal with the
things such as that audited branches are afforded 5 days.
The guideline is...
Just point me to that, please.
The guideline, my lord will find at volume 1. No. At file 3.
Okay.
Page 1113. 1113.
413.
Yes.
Z1.
It's as one. You remember, my lord, that there's been a debate about which guideline is the right one. I mean, it's proper for purposes of this case to approach the matter from the version which has been provided by the respondents.
Yes.
To avoid unnecessary dispute of fact or allegations of dispute of fact. That clause appeared, my lord, at page 1115. Where it says that following the completion of each region's audit, the National Audit Team will provide the relevant provincial secretary with a copy of the preliminary audit report. The branches will then have 5 days within which to raise queries. And I think it's been shown to me that in the answering affidavit, in fact, at page 63, so in the founding affidavit, at page 63, paragraph 87 onward, those timelines are not really in dispute. May I just probably at this juncture, Justice Kuhn, indicate that this very guideline appears to have been the same guideline which was the subject matter of consideration in Ramakatsi.
It's not province specific, it's for all the provinces. And what is, if you look at page 259, the constitution of the ANC, rule 26, What is the status of this document annexed SZ1? Is this a rule? Is it a regulation? What is it?
Well, the status of the guideline has been determined in Ramakatsa by Bisanege in paragraph 79. Where it says the ANC's constitution, together with the audit guidelines and any other rules collectively constitute the terms of the agreement entered into by its members. Thus, the relationship between the party and its members is contractual. It is taken to be a unique contract. And after making this finding, Mr. Nege went on to deal with the irregularities of the kind that we are dealing with here, and found that the elections there and the conference there was irregularly constituted, and then it set this aside. We ask in this case for the similar relief for the same reasons.
Mr. Maransela, within the context of the contract, which is set out in paragraph 79 in Ramakatsa, where within that framework does one find place for the memorandum which has been put up by the first respondent?
Yes, I would put it under the category of what Mr. Nega refers to as any other rules collectively constituted. Any other rules, and that's the explanatory memorandum is a document of much importance, having emanated from the provincial secretary of the province of KwaZulu-Natal as an instruction, as it were, or a guideline, a recommendation on how things have to be done. It can't be that now, when the shoe is pinching, he will say that, no, I didn't mean that, you didn't have to obey it. That would be a preposterous and untenable proposition.
So that would include the 70% rule?
That would include the 70% rule, if it is construed in the manner that we argue. But we say that it must be construed in the way that does not undermine the power of the branches, who are, according to the instruments of the ANC, given much power to decide these issues. And I meant to really deal with that issue, that the structure, and this is dealt with in Masenega's judgment in Ramafushi, that the structure of the Constitution, consisting of a number of rules, provides a deliberate scheme to grant branches more power in the conference decision making, and it deals with this. Mr. Nega deals with this at pages 35, paragraph 73 to paragraph 75 of the judgment, where he says that these are activities. That how members would participate. The political parties are the instruments which facilitate and regulate participation by members in the activities of a political party. And then it deals, paragraph 73, with Rule 3 in the middle of that paragraph, and says down the line that the leadership of the party is accountable to its members in terms of the procedures laid down by its constitution. And then further on over the page, dealing with Rule 5, which are the rules in the constitution, sets out that these rules include full and active participation in the discussions of the political party, the ANC in this case, and to partake in the elections in the next paragraph, and the structures and appoint structures and committees of the ANC. And with reference to Rule 23, he makes the point again that these rights take place in the branches. And he says, with reference to Rule 23, that branch is the place where members exercise their basic democratic rights to discuss and formulate policy. So the point being that it cannot, any interpretation of the 70% rule cannot be the one that has the effect of undermining the rights of the members of the branches in the way that the respondents seek this court to construe. The words of the Canadian judge, which I referred to at the beginning of my argument, ring true at this level, that whatever construction to be given to the instrument, it cannot serve to disenfranchise members of French law. That is in a nutshell, my lady, is the substance and the kernel of our argument in irregularity.
We will take the long adjournment until 2 o'clock.
Thank you.